Chambers down at the University of Richmond School of Law.
Hello, Michigan. My name is Thomas Mackey. I'm at the University of Louisville History Department and the Brandeis School of Law at U of L.
Good morning. I'm Rita McCannon. I'm an attorney in Huntsville, Alabama. I am so excited to see you all today. I have to tell you, I had a little bit of a memory of several team members, and I wondered if this morning's Michigan group might be postage stamp pictures because there were 6 or 8 of you instead of 4. I'm so glad to be able to see all of your faces and your teacher, and so glad that you're here today. We're on question 3.
Well, they should introduce themselves.
I've got to let you introduce yourselves before I get in a hurry. Please do so.
Thank you for allowing us to testify before you today. We are the Black River We the People team from Holland, Michigan, and we represent Michigan's Unit 3. My name is Piper Kendall. I'm a junior, and I'm on Units 3 and 6.
My name is Dylan Pennington. I'm a senior, and I'm on Units 3 and 6.
My name is Anya Osmani. I'm a junior, and I'm on Units 3 and 5, and our coach is Peter Letzman, assisted by Luke Ryder.
Okay, welcome, all of you. All right, are we ready for our questions? Question 3, and I'll begin. In 2020, we celebrate the ratification of the 19th Amendment, which recognized the right of women to vote. Despite recent controversy, the Equal Rights Amendment has not yet been declared ratified. What are the similarities and differences between these 2 amendments? What impact, if any, has the 19th Amendment had on women in achieving equality with men in the United States and around the world? What are the advantages and disadvantages of states passing their own equal rights amendments rather than ratifying a national constitutional amendment? And you may begin.
To us, this government has no just powers derived from the consent of the governed. It is not a democracy nor a republic. It is an aristocracy, a hateful oligarchy of sex, declared Susan B. Anthony as she paved the way for the 19th Amendment.
This amendment enshrined the American values of liberty and popular sovereignty, allowing us to lead the global fight for women's suffrage. The UK followed the American example, passing the Representation of the People Act of 1928, expanding their ballot.
Suffrage is essential to political change. In the 1930s, women were instrumental in pushing the Fair Labor Standards Act, establishing a minimum wage. And in the 1960s, for Title VII of the Civil Rights Act, which banned employment discrimination based on sex. Since the 1980s, women have outnumbered men at the polls, and today, this gap has grown to a differential of 10 million.
Yet, the US has fallen from its position as a global leader. Women make up a mere 20% of the cabinet in each House of Congress, and no woman has ever been elected to the presidency. In terms of female representatives in government, America finds itself in 76th place, tied with Cabo Verde and Afghanistan.
But the failure of the United States to protect gender equality extends beyond representation. The Supreme Court refused to apply strict scrutiny to sex discrimination cases under the Equal Protection Clause in Craig v. Boren. According to Professor Ilya Somin, if the ERA passes, courts will most certainly subject all laws with gender classifications to this heightened standard.
The broad language of the ERA leaves the door open for court interpretation. New Mexico Supreme Court ruled in Narrow v. Johnson that their ERA required Medicare to fund certain abortions. Suffrage, on the other hand, was a cut and dry issue, requiring little interpretation.
The 19th Amendment directly addressed the issue at hand, but the ERA places trust in institutions. Much of the ERA's power actually comes from Section 2, making the promotion of equality a specifically enumerated power of Congress. This would almost certainly reverse U.S. v. Morrison, which struck down part of the Violence Against Women Act, but requires us to trust that Congress would continue to champion gender equality.
Similar to the women's suffrage movement, states have taken charge in the fight for the ERA. Prior to the 19th Amendment, 12 states in some form allowed for women to vote, and today 26 have their own ERA. In regards to voting, there were extreme variations between states. For example, women in Michigan had full voting rights, but those in Ohio could only vote for the president.
American federalism allows states to experiment with policy, acting as laboratories of democracy, enabling the national government to decipher what works best. For example, Delaware's ERA only prevents governmental discrimination, but Montana's provides that neither the state nor any institution, firm, or corporation shall discriminate, allowing for more encompassing protections.
However, the lack of a national ERA does not secure a baseline standard, allowing states to choose whether or not to extend protections. With both national and state implementation, the compound nature of our republic would, in the words of James Madison, provide a double security to the rights of the people.
Finally, an ERA would adjust, most importantly, the outlook of American citizens. By cementing women's rights into higher law, it can have a greater cultural impact, protecting the self-evident truth that all men and women are equally endowed with the right to life, liberty, and the pursuit of happiness. Thank you. We are now ready for your questions.
Okay. Hank, would you like to begin?
Sure. Thank y'all so much. It sounds like the suggestion at the very end was that the ERA will change people's outlook on women inequality. Do you think that's what happened with the 14th Amendment and 15th Amendments and African Americans?
I definitely believe that the 14th Amendment and the Equal Protection Clause specifically promoted this idea of more acceptance to other races, Black specifically. And I feel that the ERA would also do this, as we already see this cultural shift happening.
In addition, we can see the cultural effect of the Constitution when we look at the First Amendment, in which we see that the First Amendment acts more, it acts not only as a lawyer's tool, but as a citizen's guide. And so therefore, because of this, there is a large cultural importance that is put upon higher law besides simply the legal importance.
Can you give me a sense of the timeline in terms of how it worked? How long was the First Amendment in the Constitution before it was used significantly? How long was the 14th Amendment in the Constitution before it was used in favor of African Americans in the way that you all are suggesting?
Yeah, I believe that since the implementation of the 14th Amendment did help the cultural shift, but we can see that many states did not uphold the values that that were passed in the 14th Amendment, and so the government did have to step in. We can see with cases such as Brown v. Board of Education, which used the Equal Protection Clause and strict scrutiny to uphold or to strike down segregation.
In addition, we can also see with the First Amendment that there is great importance in the 14th Amendment as well, because of the fact that it incorporated the First Amendment and other amendments in the Bill of Rights against the states, which means that not only can the national government not go against these rights, but these state governments cannot as well.
Yeah, but he was asking you about timeline. First Amendment doesn't even start incorporating until 1919, long after its inclusion in the Constitution. And Brown against Board is almost 100 years after the 14th Amendment. So there seems to be this important time lag here. I want to double back to what you touched on anyway, which again is the 14th Amendment, thinking about the 19th, maybe the ERA, and the Equal Protection Clause, because if the Equal Rights Amendment is more about changing hearts and minds, then can't all the legal issues and advances that you've talked about really be made through and under the Equal Protection Clause of the 14th Amendment? Help me understand how that dynamic works.
We can see with the Equal Protection Clause that matters of sex discrimination are subject to intermediate scrutiny, and the Equal Rights Amendment would provide a heightened standard of scrutiny and explicitly state that women and men are equal under the Constitution, which I believe is one of the most powerful aspects of the ERA, because the amendments to the Constitution do act as a citizen's guide.
So it's more symbolic for you.
Not only is it symbolic, but it also it has secondary effects as well, such as the fact how the Section 2 of the ERA would allow for Congress to have increased powers. And in addition, the fact that the ERA likely would end up raising the level of scrutiny that is applied when considering sex discrimination. And so this would change where the burden of proof lies, from being a burden of proof on the woman or on the man to being a burden of proof on the government.
Does a higher level of scrutiny mean that it'll be more difficult for pro-women legislation to be deemed constitutional under the ERA than currently? Hey, Dylan, you're muted.
Shit. Thank you. I'm so
Now you're
sorry
not muted.
about that.
That's okay.
Yeah.
Go ahead, Dylan.
Strict scrutiny would certainly not do that. It would grant more protection and more legitimacy within court cases, giving women often the momentum or the movement or the confidence that they need to succeed.
In addition, we can see that many laws have a disparate impact, which means that while laws may seem to impact men and women equally, it may have a impact on women that is less than men, and it gives Congress the power to enforce legislation that would ensure equality.
I have a question, but I already saw the timekeeper hold up 1 minute. I'm afraid by the time I finish fumbling, he'll hold up that hard stop sign. So we'll just talk to you a little bit. I thought it was a great presentation, and I thought you all got some really hard questions from our judges, and you were managing it. You were handling the questions. Judges, would you all like to jump in with me?
Sure. Oh, sure. I think that's absolutely true in terms of what went on. There are some real tough questions that go along with 14th Amendment and 15th Amendment and 19th Amendment and ERA, and putting them all together is hard because the ERA really goes with a bank shot, right? It says what'll happen, or what's supposed to happen, is we're supposed to not take sex into account at all, but we recognize that the way to make sure that people are treated equally is to take sex into account on occasion. So it makes it a kind of a messy thing, and I think y'all saw that. So at the end of the day, I think it was a nice job, and I appreciate the conversation.
Yeah, and my issue is that it doesn't look, on its surface, it doesn't seem like that tough a question, but you add constitutional principles, legal rules, and the cultural issues that you guys brought up during your Q&A, and in fact, it becomes quite messy, and that's part of the fun of this question, but also a challenge. And you rose to the challenge, and I thought you did a nice job of taking a position and defending it and explaining how you understand these issues. So I thought that went really well.
We didn't even talk about voting. I know you mentioned that women outnumber the men in the presidential elections since 40 or 50 years ago, but we still haven't elected but 25% of Congress, and even less than that, 25% of the Senate. But I wanted to ask you about voting and when we're going to elect a woman president. Perhaps you all are going to be, candidates one of these days and help us get farther along. No offense, Dylan, didn't mean anything by that at all.
But overall, a really nice job, I thought, folks.
Thank you.
Very good.
Yeah.
Thank you.